Following the application by Attorney General Professor Githu Muigai for an advisory opinion on the gender parity rule ahead of next year's general election, the first duty of the Supreme Court was to determine whether it had jurisdiction to hear the matter.
So there are three organizations that have raised the issues of jurisdiction.
The Supreme Court had to determine whether it had the legal basis to render an advisory opinion sought by Attorney General Professor Githu Muigai on whether Article 81B of the Constitution, requiring that at least 1/3 of either gender must occupy elective offices, should be implemented immediately in the March 4, 2013 general election, or was a constitutional principle that should be implemented progressively.
If the Attorney General of the Republic is quite unable, and we hope he's not, to offer the guidance that he's expected to offer under 156, then the Kenyan people would be entitled to seek that guidance from this court, which in that same matter said it is the court of final judicial authority.
However, some lawyers argued that the Supreme Court had no legal basis to determine the matter, since the Constitution had not provided a mechanism on how to ensure that at least 1/3 of the members of the National Assembly and the Senate are either men or women. This, they argued, was a political issue that only the Kenyan electorate through the ballot could determine.
And my lords would urge the court to note that this is a matter that is of paramount significance to the ordinary Kenyan voter.
The five-judge bench comprising Dr. Mutunga and Justices Philip Tunoi, Njoki Ndung'u, Smokin Wanjala and Professor Jackton Boma Ojwang ruled that the advisory opinion request from the AG was properly before the court.
So we hold that we have jurisdiction to hear its reference. The AG must file responses to the submissions of interested parties and Amish Kuria not later than November 14th. And we will hear this matter at 2:30 p.m. on November 20th.
The Attorney General and key stakeholders in the implementation of the Constitution have argued that the country could be plunged into a constitutional crisis if the next National Assembly will not have at least 117 men or women. The National Assembly in the new order will have 350 members, 47 of whom will be women representatives elected from the country's 47 counties. Even if the 47 women representatives and 6 nominees made their way to the National Assembly, at least 64 constituencies must elect a female member.
And it will create a constitutional crisis of unparalleled proportions, because we will not then have a parliament that can undo the harm. So we will be in this paralysis where we have an illegality that needs to be cured by parliament, but we don't have a parliament that can cure it.
Attempts to craft a formula in parliament flopped, forcing the Attorney General to seek the Supreme Court's opinion. As the court with final judicial authority, it's now all eyes on Dr. Mutunga and his team as they make a ruling that will be binding on all Kenyans. Francis Gashuri, Citizen Live at 9.